this is a place you can send them. I would imagine that maybe as you get towards the borders and all that kind of stuff, where there's a lot of commerce across different, country lines, you may see that. And maybe Guam and Puerto Rico may have some of that as well. All right, the contract formation process. Let me tell you where we are now. Take a step back. I know we've reached the water, the refire holes kind of thing. Are you thirsty? I know we're there now. We talked about just the FAR administratively. We talked about the acquisition process. Let's assume that they've now got ready and they've awarded the contract. Now we're actually going to form the contract and go through the contracting process. So now we're at the point where a client calls you and says, man, I just received a phone call and that full and open thing, that was best value that we had no shot of winning, but we just put our proposal out there just to get our name out there. We just got a phone call and we're actually going to win it. What next? Okay, here's some of the what next, right? The what next. General principles of contracting promises. Keeping your word. These are things, just basic business concepts. The general contracting, there's two concepts of general contracting. One is the good faith and best effort. Both parties are negotiating in good faith and with the best effort to do the right thing. That's where all the verbal speech, keeping your word, promises, all those things happen. However, in federal contracting, once the contract comes out, promises kind of stop. Everything now is based on what's in the FAR, what's in the contract. So at that point, handshake agreements no longer happen. So on the front end of negotiating, going through the contract, it's all about confidence promises. The government promised to put this statement of work out that they can unilaterally cancel, including the options. But the contractor promised to deliver certain services. They promised to deliver key people. That's another big issue that the government's having. These folks are putting in key people. When the contract, key people don't show up. All that's part of this promise concept. What is a solicitation? Again, a solicitation is this, the formation of the offer. It specifies the procedures that they're going to be selecting the proposals, and it also talks about the simplified acquisition procedures. In many instances, the solicitation is the basis of the proposal. It is the basis of the contract. I've seen solicitations that once they were awarded, and you read the contract, with the exception of the clauses, they were pretty much identical. They just signed the SF 1449, gave it right back to the contractor. That was their contract. An offer is a response to a solicitation. And again, this is just the definition part to confuse some of the terms, and what's to not confuse some of the terms and help you guys navigate through some of them. The offer is the response. A contract is the formal promise. It spells out the duties of each party. There's a common law system. Everything in the FAR is actually based on, a lot of the stuff based in US-based law is based on the common law system. I'm not going to open that door because there's at least 1 to 3 attorneys in here that could probably get up and give a whole dissertation about the common law system. I don't even want to open the door for that. But there's a lot of the terms that we read. It's not the way we speak now. You can maybe like the old English kind of language and vernacular. It's because it's based on the common law system. There's 6 elements for a contract to exist. Again, in federal contracting. States may have their own rules, counties, commercial. Page 104 to 106, these are the 6 elements of a contract. Mutual assent, there's an offer acceptance, there's consideration, that's slang for money. I know there's some conferences that are $0 contracts, those are exceptions, but there has to be consideration. Capacity, both parties have to understand the agreement. It has to be a lawful purpose. I won't get into spying and all that, and but it has to be a lawful purpose. I have to say that because it is a contract, right? Certainty of terms, it has to have typically a clear start, a clear end. I know there's undefinitized contracts, there are some exceptions, but it has to be certainty of terms and a form provided by law. For the most part, we're talking about the SF 1449s, SF 30s, GSA forms. But these are the 6 elements for a contract to exist, federal. Role of the contracting officer is to ensure the contractor receives impartial, fair, and equitable treatment. Man, I can get on the soapbox here and say, just think about that. It's the contracting officer's job and responsibility to make sure that the contractor receives impartial, fair, and equitable treatment. If you talk to most contractors, they'll take the contracting officer, man, trying to get the best deal for the government, which is not impartial, fair. I'm just saying. That's the FAR definition. The contracting officer must always balance the duty to get the best deal for the government against the obligation to act fairly with respect to the contractor. You're going to get a call and you're going to say, hey, I asked you what to do for some advice to deal with the agency. I took your advice, called the agency, told them it was in the FAR, and they said they didn't care. I know it never happens, but this is the essence of what the contract officer is supposed to do. In reality, you may find yourself in a situation actually saying to a client, you have 2 choices here. You can be right or you can be happy. You can choose. Sometimes the cost of being right is too high. We'll just share that with some of the new folks. Role of the Corps. So let me go back on that, because although it's not in the curriculum, let me just share this. Contracting officer takes a lot of different shapes and forms. You're going to see like CO, KO, PCO, ACO, all procurement official, PCO. For the most part, that all those vernaculars in the federal government, they all mean the same thing, the contracting officer. Same thing is happening with COR. You'll see COR, C-O-R, you'll see COTAR, C-O-T-R, a lot of different things, but they all mean the same thing. I think HUD has some funny vernacular called delegated something or another. The COR is the technical person. They're responsible for putting stuff in the CPARs and PEPRs. What that means for the new folks, the contracting officer awards the contract, they control the money, but past performance and how well you're doing and how well your client's performing, the COR controls that. So that's where the conflict actually happens. So I guess this is the consulting piece, right? It's the contractor, it's in their best interest, let me say it academically right first. It's in their best interest to do right by both parties. It's in their best interest. But the COR is typically the one that puts out the requirement. It's not uncommon for the COR to go to the contracting officer and say, hey, I need this, and I want to use them. The COR is the one who the incumbent can work with, help identify new needs, and then the COR goes and tries to get a change order to grow the contract where it's not even competed. It's just a change order or a modification to an existing contract. The COR is also the one that goes into the past performance system and says whether you perform adequate, acceptable, marginal, and they even put notes there and says, hey, we use them again. So as a contractor, they have a natural inclination to want to make the COR super happy because of all the follow-on opportunities. The problem is when they're doing things that are outside the contract, they piss off the contracting officer who holds up the invoice, cancels the contract, send them all these calls, notice, and cure notices. So just be mindful that when you're talking to your client, they have to understand that whatever the COR wants them to do, they should try to do it after the CO is brought on board for the conversation. That's a common mistake that new contractors make, and I would encourage that to give that advice. The COR, you want to love the COR, but the CO is actually the administrative point of contact, and each CO actually appoints the COR. It's not the other way around, even though it can feel that way sometimes. The CORs work for the CO. Unauthorized commitments, everything we just talked about, unauthorized commitments. Contractors make a lot of promises to CORs, deliver things. Per the FAR, those are called unauthorized commitments. Government bid negotiation rules. Page 110 provides with a chart. I won't go through the chart, but it goes through different provisions, negotiation rules. The key concept there is that the government can only ask about the contents of your proposal. You can only ask about the contents your client can only ask about the content of their proposals. And if they're going into negotiations, they should also use something called the Cost and Pricing Reference Guide, CPRG. Write that one down. It's important for your client to read this because that document tells the government how to negotiate. So understand the value of that. That document, I think it's like chapter 5 or chapter 6. It tells the government how to negotiate. So if your client can read the document on how the government is supposed to negotiate, they walk in with a leg up. It says stuff like, tells the government, give away concessions and things that are not monetary. Hey, you want to bill us, net 14 versus net 30, we'll do that. Hey, you want to do the report by the 10th day instead of the 5th day? Sure, you can do that. So now you get the price, the government's giving away so much free stuff, can you get this down 15%? Oh no, I really can't. We've given you everything you've asked for, now you're going to push. They want to read that. It's like the art of war, you want to know what's coming at you. So CPRG, negotiations, is a good document to read. The uniform contract format, this is the standard document for the federal government. Provisions and clauses, we discussed this when we talked about ICE earlier. A solicitation provision means a term or condition used only in solicitations and applied only before contract award. The contract clause means a term or condition used in contracts or in most solicitations and contracts after applying after contract award or both before and after award. Again, gobbledygook, right? The concept there is that when they get their contract, go through there and they have to read all the contract clauses. One of the most missed contract clauses is if the company has a contract with option years, they don't read the part that discusses how the options will be exercised. So in there, it actually spells out whether the government will notify them within 30 days, prior to the end of the base year, 14 days, 17 days. That's important to know for your clients. It's one of the more missed concepts because they should send a proactive email. Pursuant to our contract clause so-and-so, you guys are going to let us know by day 30 before the contract ends if it's going to renew. We're at day 35, what's your intent? Because once the government gets inside those 30 days, it would now require a negotiation in the mind to happen. Plus, it's also helpful for that contractor to know if the government plans to continue their contract. That way they can make plans for their resources and their people in the event the government's not going to do it. So again, a lot of contractors, they're sitting there twiddling their thumbs, not knowing if their contract is going to be extended, when in the section it actually tells them the window for which the government must do it. That's one of those fun ones that's in there that no one reads. Where is the text? Again, FAR 52. FAR 52 contains all those provisions and clauses. Most people don't read the FAR 52s because when you read FAR 52, it says go to FAR somewhere else. But that's where they find out where the clauses actually apply. So again, we talked about the ICE thing. FAR 52.2 something or another will say, because of this clause, FAR 31.xyz applies. Well, it's in FAR 31.xyz that says this contract's going to get the audit. But they didn't read it because they read the clause referred to somewhere else. And, most people, once they do that first two or three clicks, they're done. But the 52 clauses, those are the clauses that list all of the typical contract clauses. Prescriptions, they called it prescriptions. Every provision in 52 is prescribed at the place in the FAR text where the subject matter provision or clause receives primary treatment. Again, when we say that the clause is what makes the actual FAR applicable, the federal term for that is a prescription. The FAR term is prescription. So, tie it all together. In order for ICE to be in effect, the prescription has to be in the contract. Again, this is somebody that probably used to be a doctor, decided to come to the federal contractor and say, why don't we treat these things like prescriptions? And don't ask me how I get there. Amending a solicitation. So here's what I'll throw out there, because a lot of these slides I'm going to go through. There's two terms that are used in federal contracting when it relates to changes. You have amendment and you have modification. A lot of contractors don't know the difference between the two. And that usually gives a contracting officer an indication, or really a large prime contractor, an indication of how much they know or don't know. I'll give the government the benefit of the doubt and say that they're not really apt or likely to try to exploit a small business. Large businesses that are driven by profit, they never do it either. But this is the first indication. An amendment is for a solicitation. Modifications are for contracts. Make sure you know this. A lot of state levels, terms used interchangeably.